Wrong! Here are 5 things not to do when trying your case. I'm Dan Christensen with DJC Law. First thing, a lot of lawyers are scared about bringing up a weakness in their case in front of the jury during jury selection. Wrong! That's exactly what you should be doing. Talking to the jury about those issues that concern you most in your case and allow them to deliberate right in front of you so you know how they're going to react to that evidence that you eventually present. Do not be scared to talk to the jury during jury selection about the weak parts of your case. Second thing you need to avoid is objecting to your opponent just for the sake of objecting. Wrong! You have to evaluate when your opponent is presenting evidence whether you want to object, if strategically it makes sense. Sometimes it's not bad if your opponent does something objectionable. You don't want to draw attention to it with the jury or the judge by standing up and alerting everybody that this evidence is not good for you. Sometimes that evidence that's objectionable that you allow the other side to put in will open the door for you to introduce some rebuttal evidence that wouldn't otherwise be admissible. Don't object just because you can. Evaluate whether you should. The third thing you do not want to do when presenting your case, attack a witness before the jury has implicitly given you permission. Wrong! What do I mean by that? Oftentimes as lawyers, we want to have this big dramatic moment with the witness, especially a witness who's hostile to our case, and we want to destroy them on cross-examination. But we get too aggressive with that witness too soon. The jury is always going to side with the witness over the lawyer until it becomes apparent to the jury that that witness is being evasive or is not being truthful in some way. And in that situation, once you can sense that the jury has come to that conclusion, then at that point you have permission to attack the witness. Do not do it before then, because then you as the lawyer will appear as the bully. The fourth thing to avoid when presenting your case is having your client at the counsel table whispering, reacting to the evidence, frantically scratching out notes to you and showing you the notes and making facial expressions in front of the jury. Wrong! Counsel your client ahead of time that they cannot do anything like that because the jury is watching. Even though that's not evidence, the jury will absolutely be basing their decision, at least in some part, on how your client is reacting to the evidence that's being presented. The fifth thing that you want to avoid doing when presenting your case is taking too much time. Wrong! Many of us lawyers are type A, nitnoid people. We have to constantly cover every single corner, every single basis. We go through and we cover way too much material, and we do it repeatedly over and over again. The jurors don't like that. It's a waste of their time. The judges don't like it either. It causes the entire case to take too long. Don't do it.